I'm Susan Hoffman, and we're going to discuss preparing for your deposition. It is very likely in your case that your deposition will be taken, and you need to start out by first knowing what is going to be the purpose of your deposition. Is it going to be a deposition that's limited in scope, such as to temporary support, to a parenting plan, or to a requirement before going to a hearing that the court has imposed you must first have a deposition before the court will hear the case? Or is it going to be a general deposition that covers all issues? You then need to know if you have been requested to bring documents to your deposition. Many times a subpoena will be issued requiring you to bring documents to your deposition. Most importantly, you need to talk to your attorney in advance to find out how does he want you to act during your deposition. Does he want you to look to him for responses? Does he want you to just answer everything? During depositions, objections may be made, but most likely the objections are just for purposes of preserving the record, not to be limiting your testimony during your deposition. However, there are times when certain items cannot be discussed even during your deposition. So you need to address that with your attorney and find out what he wants you to respond or how he wants to take your cues from him. And finally, what you need to know is the general rules of depositions. Frequently, a question may be asked of you during your deposition that's a yes or no question. One of the most important general rules is to answer yes or no if it's a yes or no question. Do not provide more. A deposition is a form of discovery, which means the attorney that's taking your deposition is trying to discover issues or discover areas where he may want to go into further discovery. But you do not need to do his job for him. So if he asks you, is it raining outside? The question is either yes or no. Is it raining outside? Not, yes, it's raining outside, but they say it's supposed to stop. Don't give anything more than what is asked of you. Do not speculate, and most importantly, always tell the truth during your deposition. But do not guess. And if you don't know what is being asked of you, it is fine to say, I don't understand your question. I don't know what you mean by that. What is it you're asking me? You can do that. You can also take a break during your deposition if you feel you need to talk to your attorney. In that instance, just take a second, say, I think I need to talk to my attorney, and step out. Your attorney at that point will then discuss the issue with you, maybe how he wants you to address the issue, how he wants you to respond to the issue, and you will step back in and finish your deposition. Finally, at the conclusion of your deposition, you will be given the opportunity to either read or waive reading of your deposition. What this means is when the court reporter transcribes your deposition, she will give you the opportunity to review the questions and your answers and note whether or not you feel she correctly put down your responses. 9 times out of 10, your attorney may say we're going to waive because he knows the court reporter, he knows her quality of work, and does not believe that time needs to be wasted in reviewing the deposition. However, keep in mind it's always your case, and it's what you feel comfortable with that's most important. And good luck on your deposition.